we have an interesting session on specifically we will talk about how to make a good legal research report. And we will go into details of what are the important characteristics of a good research report. We have an advice we will on specifically we will talk about how to make a good. So what we will do is we will go over all the features and important points which are required in a good legal research report. We will also show you some sample really good legal research reports. Some have been made in-house by our team, and some are obviously by other third-party, some of the best companies in the world and law firms who have made the report. So it's like a case study. So we'll study from the best reports which are there. And then in the last section, we will talk about the reports which you have also made. So, and we've also identified some of the best reports which we have received so far. And we have graded some of them as A+, and the others are all in that A category. And there is no perfect report anyway, as we had discussed earlier. I also we have Parth and Neeraj who are in our admin and backend IT team to support us. Pushpit Singh is also joining us. He's a law student, but one of the brightest and the best, I would say not just in India, but probably across the globe. And he's actually heading our legal research team. Okay, we have lawyers also, but as a student, he writes excellent reports, and he will help me today in going over the way how we have to, what are the fine points which we have to keep in mind, what are the do's and don'ts of legal research report. Because as a lawyer, I think it is really, really important for all of us to fully understand and appreciate why and the importance of legal research reports, why it is important for all law firms, for all lawyers, for anybody in the legal fraternity to not just read legal research reports, but ideally we get trained to make them as well. And some of the largest and the biggest law firms and consulting firms make a lot of legal research reports. So it's a huge industry by itself. And later on, you could specialize, like you could choose to be a litigation lawyer or a corporate lawyer or a civil or a criminal, but you could also be part of a legal research writing team. It's a profession by itself. So I'm going to hand over to Pushpit right now to briefly go over. Some of you may have got some information about it, but I thought it's important enough for us to go through it in detail to start with. So Pushpit, would you want to take over, briefly introduce yourself, and we will jump straight into how to make the research report, and then you can share the screen share as well.
All right. Good evening to everyone. My name is Pushpit Singh, and I'm currently a law student, second-year law student. And as rightly told by Sir, there is no perfect legal research report. So jumping right into it, first I'll be differentiating between certain things that are really important to set everything in perspective. First of all, when you write a legal report, a legal article, there are two types of legal articles actually. There's research article and there's a professional article. In a research article, you criticize the law and you tell it and you give your own analysis and interpretation to it. You tell that, okay, this is the law, and then you give your suggestions to it through legal backing, of course. And then after that, there are professional articles. Now, what are professional articles? Professional articles, you don't criticize them. You just tell that this is the law and this is what it can be used for. Basically, you are the employer and you're just giving an advice to a client through the help of a legal article. That's all. So in our internship program, what we aim at is kind of trying to mix the both. How? So first of all, I want all of you to understand that when you're writing a research article, all right, we have differentiated in the research article into two parts, research note and research report, that we are all aware of. However, the common factor between a research note and a research report, the most important one, and the same was mentioned in the rules, was analysis and interpretation, because that is what adds value to your research article. Now, what is analysis and interpretation? Now, before I get into that, I just want to explain it through an example. So let's say analysis. Let's talk about the in the Indian context about the Indian Penal Code. Section 375 talks about rape, and there are two exceptions in that. Second exception says that any person, any man who has sexual intercourse with his wife that is below the age of 18 but above the age of 15, that's not rape. Now everyone talks about marital rape. They talk about exception number 2. But no one talks about exception number 1. Exception number 1 just talks about that medical procedures used to test a rape victim. That does not constitute rape, but still, it does, because it attacks a woman's integrity and bodily integrity and privacy. No one talks about that. Now that is where your job as a researcher is to analyze that topic and talk about it. Now let's say if you want to talk about the exception 2, all right, go ahead. But as there is a lot of literature available on exception 2 already, your job as a researcher is to bring a fresh perspective to it, a new point of view to it. And to be able to do that, you have to go very in depth, because everyone has already spoken about it. So you need to see the differentiating factor, what sets you apart. So why that, I would like to point out the general errors that were there in almost all of the reports. So what problems that we faced was that how to do an analysis and an interpretation, but that is not there now. But there's a new problem in itself, which is very unique. A new analysis and an interpretation is required. Now, what do I mean by that? I mean that, let's say you have analyzed a section of law or you have analyzed a provision of law. The problem arises that with the analysis you have given, it has already been covered by someone else. So you have to cross check if that analysis has been covered or not. Because if you're just repeating the same thing, it does not really add value. Because in research articles, there is this one term that we adhere to always. It's called a research gap. In a research gap, we need to identify what is that research gap and how we can fill it. In simple words, a research gap is nothing but a gray area in law that no one speaks about. Or it can also be, again, an old thing, but a new perspective. Simple as that. Then, after that, a second mistake was that people were taking non-legal topics, in the sense, let's say I take cybersecurity. All right. But my job as a researcher in the legal field is to relate it to law by talking about cyber law, by talking about the provisions available, if there are any. If there are no provisions available, then what is the next step? Then after that, the third mistake was that some people were clubbing analysis and conclusion. That's not how really it works. Analysis and conclusion are two distinct identities. Analysis is your own interpretation, is the way you have analyzed the law. Now, when you're analyzing the law, you have to use sources. I'll come to the sources part later, but this is just for the sake of understanding. After you're done with the analysis, then you go on to the conclusion. And even in your conclusion, we have given in the rules that it should be conclusion plus recommendations. Now, what are recommendations? It's nothing but the alternative. Like, let's say you want a provision of law to be deleted, then what about it? What after that? That's a recommendation. So you had to give recommendations. And when you're giving recommendations, always keep one thing in mind. Telling we should spread awareness is not enough. You should always go beyond that. You should say how to spread awareness, where to spread awareness, when to spread awareness, through whom to spread awareness, and are there any provisions available for awareness, like that. Then the fourth mistake, that was all of the topics were great, all of them. But again, the ones that were selected, they lacked analysis and interpretation, in the sense that they were beautiful topics. Like some spoke about contempt of court that no one speaks about now, but as it's a hot topic in India, they're speaking about it now. But again, it lacked that analysis and interpretation that we're speaking of here. That is why it was a great topic. It had potential, but it was not utilized properly. So when you're taking topics, ensure that you squeeze the entire potential out of that topic through in-depth research. And keep one thing in mind: research in a day is not possible. You have to put it depends, of course, from person to person, but to generalize it, research in a very short time is not good. It's not productive, it is not quality. And then after that, people were taking very highly subjective topics. There was one there was few topics, like for example, the one of the topics was, is the World Health Organization biased in nature, or something along those lines. Now the problem with that topic was that there is no concrete evidence to prove your research gap, that yes it is, or no if it is not. It's really difficult. It's a very highly subjective topic that does not really have any sources to prove your topic with. If you do, that's great, but if you don't, then you should try to avoid such kind of topics, because they're highly subjective. It's like talking
Sure.
about religion. It always changes from person to person.
Sure. Pushpit, thanks so much for this analysis. What we'll do is, let me give it some more perspective, and then we will continue
Sure, sir.
with your comments on this. So very, and let us also start showing some, the documents which we had given. Let us go through the guidelines also. So let's put the guidelines up also, and quickly we will go over them. Okay. Can you put the guidelines also up on the screen share?
Sir, I'll share the screen.
Yes, please. You
All right.
share the screen.
Just
And see, the idea is that we are not here to criticize any report, right? Idea is that all of us learn and improve. So within our, all those students who are joining us today, there are some who are really very, very good at making the reports. We just need to maybe very, very few suggestions are required. They're really fantastic. And we have actually identified 13 students whom we have invited on this Zoom session also right now, because the reports were spectacular, out of this world. They have blown us. Okay. And there are many students who maybe it is their first attempt to make a legal research report, because somebody is in the first year, somebody is in the fifth year. We have somebody who's also from the, who's done their LLM, and there are practicing lawyers also within this group. So let us, and again, and Pushpit will speak a little bit more about specifically is, yes, these topics, we are trying to pick up new topics, but when we start out making a report, I think it's not a bad idea to Google what kind of research reports are already available. Okay. Just to get an idea what, if somebody is already made, and we are also doing exactly the same thing. And obviously the idea is to make it your own and make it original. That is our starting point. But not a bad idea to see what are the best reports available. And in the top 10, 20 on any topic you will find. So that is why it is very important to select your topics very correctly. If you are selecting new topics, it will definitely, you will have much less reports. And there is no point, I think, in making research reports absolutely on topics which have been covered hundreds, thousands of times over, unless you are able to add some new value to it, either by citing some new case laws, or there is something new which has happened in the last few months or last year. Right. So these are some of the important topics. So very quickly, guidelines. Yes, we must have a cover page. We must have an index, introduction, chapters, conclusions, and recommendations. It's like writing a small book. If you're looking at the research articles, it's literally writing like a mini book. Okay, now not all of us are going to become authors, but idea is to work on those. The research notes are short, concise, and simple legal research articles. So, and in our course of being a lawyer and practicing law as a profession, you will realize how many research notes and reports we all have to write. Sometimes we will write independently, sometimes teams are writing it together. In fact, some of the larger companies and law firms, no one individual writes a research report, because it is a very, very vast topic which is to be covered. So there are teams of anywhere from 2, 3, 5, 10 people, and then there would be a lead person to make sure that everybody is researching on that specific topic in which they have to make the report. Okay, so Basic format, we have just given basic guidelines like the margin, size, file format, line spacing, alignment, text, font style, font size. Now, these are just guidelines which we feel, in our opinion, um, Pushpit, myself, as SFLRE, as Dayal legal, we feel that these are good basic templates to keep it simple, rather than having very large fonts. Presentation also, your content matters, but presentation also really matters. How you're presenting your report, you could have all the same information, but is it properly conveyed through the report correctly or not? So citations, Pushpit, I think next topic which you need to cover now is on citations and on sources, and making sure that if there is any something which we are copying, then there is, it does not amount to plagiarism. And how do we ensure that we are not? And if we are taking somebody else's um, work, then we give proper credit to that individual. So, Pushpit, would you want to speak on these two or three specific topics right now? And then we will do the analysis at the end of each individual's reports.
Sure, sir. Sure. All right. So in law, we have a very common citation format. That's the Blue Book citation style. However, there are two, again, 19th edition and the 20th edition. 20th edition is a little bit more difficult to find, but 19th edition, the format, the how to go about it is widely available. So that's why we have given 19th edition. Now, why do we cite? We cite because we do not have a problem of plagiarism. What is plagiarism? Again, we cannot copy someone else's work the way it is. If we read other people's work to understand, to form an opinion of the same, and we cannot copy their idea. Basically, the entire point of plagiarism is we cannot copy a different person's idea. We can read other person's idea to form our own idea, or if you're directly taking some idea or some part of their work in our report, we have to cite it. Now, there are the different ways of citing, either putting it in the form of end notes, that is below every page, or in the form of footnotes below every page, or end notes at the very last of the page. Now, we have to ensure that if you're taking something, you cite it, because if you do not cite it, the problem of plagiarism arises, and it should not go below 50 above 15%. That has already been mentioned there. So after that, sources. Now, this is a major part of how
Sorry,
you.
Pushpit, so it should
Yes, sir.
not be more than 15%. Is that what you're
Yes,
saying?
yes,
Yeah.
yes.
Okay. And which are the normal sites for plagiarism, which somebody who's not familiar with, which ones are we using these days more?
So basically, universities, they have a tie-up with this software called Turnitin, but the free softwares that are available online, they range from one to another. But I think a credible one is to use Grammarly, because that's the most popular one that people use. It can also be used for checking a grammar and checking a language. It's a very basic and a free
Sure.
version that everyone can use.
Excellent. And the basic source of law, what is it that we are suggesting students to start using?
Right. So there are two sources of law, primary and secondary. When you write a research report, our major focus is to focus or derive our interpretation and analysis from the primary sources. That can be case laws, statutory authorities, that's the statutes, the acts, the rules, the procedures, the codes in your jurisdiction, law commission reports, then international and national treaties, policies, etc. So the information that you take, the opinion that you form, it should be majorly based off this. And a very good way to form opinions is through case laws and is through law commission reports, because they tell what is the problem, and they can tell you that this is where that probably a research is required, or probably where you can, as a researcher, come in and give your recommendations or suggestions. After that, secondary sources. Now, it is not advisable to always base off your opinion on secondary sources, because secondary sources are someone else's opinions. Now, what can they be? They can be journal articles, books, governmental websites, etc. Now, why are secondary sources used? They're used to give an additional perspective to a person's research, to be able to give that extra edge to a person's research report. So that is why secondary sources can also be used, but not heavily relied upon. That has already been mentioned, as here it is. And one important thing, we cannot focus on one side of the party or the other. We always have to remain neutral while writing our research reports and while also selecting our sources of law.
Yeah, I would also like to add here that our personal opinions really in favor of a topic, I think that is where the research report important part is that it has to be very balanced. Our personal biases, whether political, our views on a particular law, whether we agree or not, should not matter. Like a lot of people ask me also when I'm making a report, like, what are your views? Yes, we are writing the report, but if you look at it, it's essentially you will be part of a large organization which is actually making a report. Okay, even if you're writing by yourself, but we should not color it through our own eyes alone, based on our experiences. We have to give a balanced view that let the viewers or the readers decide. We just have to give both the sides of the advantages, disadvantages, rather than just focusing on one specific side. Very, very important to make a note of that. Pushpit, we also need to speak a little bit about the sources of laws, because we have participants from different countries, and we ourselves could be living in one country. We could be from Argentina or Nepal or Kathmandu or Pakistan, but we are writing on international subjects. Could be like M&A or cyber law or international arbitration, right? So let us also a little bit help everybody in trying to figure out where do they find the case laws, which are the sites to use in their home countries, and sometimes, let's say, for US, Europe, UK, and internationally. So let's move on that as well.
All right. So I'll give the example through the help of India's context. So
And
here,
let's make it very India specific only. We need to give,
yes.
let's look at it at an international level also. So,
Yes.
okay. So, yeah.
So when you find a case law, you read upon the topic and you see if there are any judgments available on it or not. You see whether any judgments are available on murder or not. When you do that, you try to go and look at it first at the court's website. But in India, we already have legal databases, and in USA, UK, and in those countries, there'll be certain legal databases. If there are no legal databases, then it is always advisable to go to that particular court's, the particular jurisdiction court's website and check for the websites. So how do you find the judgment? Usually what happens is when you go to the court's website, they'll ask you the case number. So it's highly likely that when you're reading about a judgment in a newspaper or in a journal article, they're likely to give the case number. And you can use the same case number in the court's website to be able to get the copy of that judgment or whatever it is, or of the order. Now, if it's an international judgment, let's say we're talking about the South China Sea dispute, you go and check the tribunal's judgment. So because it's a maritime dispute, it's very niche, it's very specific. So you go onto that particular tribunal's, the maritime tribunal's judgment, international maritime tribunal's judgment, and check that what is the judgment, and that judgment will be available on the tribunal's website itself, because it's really difficult to be able to compile all of them into one single legal database. So it's always advisable to go to the court's website and finding the article. Or you can always do this little trick. You can just write the petitioner versus the respondent's name, and then after that you can just write PDF. So if you write PDF, you will be able to find the PDF copies of the judgments. But to be able to verify the same, just check if it is from a credible source or not. You can just check it in the hyperlink. It'll usually be .gov or dot whatever the country's jurisdiction's website is. So accordingly, you can try to find those judgments. It's a very simple way of going about it. It's not a very Herculean task to say.
Right. And also the fact that sometimes the judgments are really, really lengthy. The final judgments in Supreme Courts, whether in America, India, UK, any country. And what are we trying to do? We are trying to simplify them, right, for the readers who could be lawyers, and many a time the research reports really are valued by people who are not lawyers, right? It's for clients. It could be for CEOs of companies. It could be for the management board of organizations. It could be for the finance heads of organizations. So what we're trying to do here also is to simplify the very complicated, cutting out the legal jargon. And I think simplicity is at the core of it. Can be simplified and not use Shakespearean English or use Latin and phrases which nobody understands without looking at a dictionary. So idea is to simplify that a 10th class student should be able to understand. Anybody who understands basic English should be able to read and understand these reports. So always keep in mind that yes, we are dealing with very complex subjects, but our idea is to actually simplify it. Okay. And yes, the judgment could be 18,000 pages maybe. Okay. How do we simplify it in 1 page or maximum 2 pages? That is the challenge. Okay. What key points do we pick up from? And that is what we as lawyers are also doing. The cases which we fight in the courts are complex matters, whether corporate, personal, whatever. The files are voluminous, but we have to put it across honorable judges in a matter of 5 minutes or 10 minutes max. Similarly, what is it that we need to pick up from a 10,000 page judgment and put it on a one sheet of paper that this was the law point, which is the gray area. Okay. We put points from both the sides, and finally, what are the honorable judges? Finally, what is the judgment? Without commenting that I don't think it's a good judgment, it's not our job. But finally, what was it decided upon? That is where we need to keep our personal emotions and feelings away from it. Okay, so I know it's difficult, but we cannot say no, it was not a good. Every judgment, one can always debate whether it is right or wrong, and one party is always unhappy with the judgment traditionally, right? But we are not trying to criticize the judgment itself. We are just trying to analyze the judgment. So, and because that becomes the new law, that becomes the precedent on which new similar cases will be decided. So it's very, very important. So case analysis in any report is extremely, extremely important. And obviously, we are looking at current ones. So a report on a particular subject, which is 3 years old, today has very less value because after that, so many new cases have been decided and new facts are coming in. And what is the current interpretation? So we do have landmark judgments, which could be very old, but they are fixing the benchmark. Okay, we need to look at landmark judgments, and if you Google landmark judgments, you will. So it's like there is so much of information available on the net today. So first of all, how do we find out the authentic information? Which are the government websites or the Supreme Courts of various countries from where we pick up those information? Because how do you differentiate that whether it is authentic? Because your whole research report is standing on the pillar that your basic source is correct and authentic, right? So yes, we look at government websites, primary and secondary, as Pushpit has just mentioned. We also look at case laws. And finally, in terms of Pushpit, in terms of citations and judgments, I think a little bit more. You want to add anything else?
Sure, sir. So just coming on to your question, how do you summarize a 10,000 page judgment in 1 or 2 pages? So if all the interns would have observed, we have in the research note, we have the format. We have the facts, problem of law, analysis, and conclusion. That is nothing but the format of a case brief. What is a case brief? For summarizing the case in 1 or 2 pages. So the entire idea is to ensure that you're able to write all of that in 2 to 3 pages, not more than that. Now, a major part comes in to be able to write everything in a case brief in very simple sentences and not in more than 2 or 3 pages. Because one thing that we have to keep in mind is that you have to summarize a 10,000 page judgment and you have to find the relevant parts. Now, how do you find the relevant parts? It's not advisable to do Control F and just type the keywords, because it's not really a good idea, because different parts of the judgment can be relevant as well. So you have to develop a habit of reading in that case, because that is where the hard work comes in, because that consistency will go a long way, where you have to get the habit of to be able to skim through the judgment in like few hours, or if it's a long judgment, few hours, or if it's a small judgment, in few minutes. You have to be able to inculcate that habit. And how do you do that? It's a very normal habit, through reading books or through participating in moot courts and through different activities. So it's the onus is on you to be able to read the judgment in a matter of few minutes or hours, and then to be able to verify whether the judgment is authentic or not. Just go to the court's website and write the case number. If the case number if the case exists, you will be able to find it through the court's website. That's the best way of verifying whether a case law is real or not, because it's possible that a case law might be fake on the internet, because it's highly likely. To be able to verify that, just verify it from the court's website. That's a very easy way of going about it.
Sure, because just because some information is available on the internet does not mean it is authentic. Okay, so I think that we I think highlighted that many a times. But should we just go over some of the sample good reports which we've kept, and we have a report from your side also. Let's start off with that one,
Sure.
and then go over. We have got some. Just put it on the share screen. So what we're also going to do is, we have selected some really, really good reports. One is made by Pushpit himself, but the others are more from law firms and consulting firms globally. Okay. And yes, it is important to look at them, review them, so that in future we are also able to make very similar reports. So this one is by Pushpit, which is on, I think Pushpit, you just quickly run through this in about a couple of time, and we'll go to the other ones.
Through this report, I'll just explain the interns how to create a good legal research report. So this is a research article that I had created. An abstract is nothing but a summary, but in our in SFLRE, we just have it in the form of introduction. And then now, before you write a research report, research article, you have to mention certain things. You have to identify what are the research questions, and you have to identify then what is the hypothesis. That's a very technical term, but just to put it in simple words, what do you desire to get out of that report? What do you want to get out of the report? What do you want to prove out of that report? And then research methodology. How are you going through it? Through primary sources or through secondary sources? And then after research questions, you statement of problem. That's nothing but the research gap that you have identified. And then after research questions, you have research objectives. Before formally starting a report, always ensure that you have these things in mind: research questions, research objectives, research gap, and then hypothesis. Hypothesis is a very technical term, but just to put it in simple words, it's the desirous outcome of a research article. So let's not get into too much technicalities in there. So after that, it's nothing but how you write the article. So this is my one thing that I would like to tell all of you, is that sub characterization in an article is very important. What do I mean by sub characterization? You have to divide the report into different headings and subheadings. Putting the entire report under one heading is just, it does not make the cut. You have to identify what are those headings. So for example, it's the definitional challenges, and then after that, I have put the intermix of the formal and the non-formal legal system. This is nothing but characterization of the.
And can you just like a little bit more on the footnotes, how you have?
Yes, sir.
Yeah, just spend some time there.
So when you're citing something, so let's say I have used this particular paragraph from a particular source. Now, the source that I have used, I have written it, I have cited it, and that is in the form of footnote number 4. Now, supranote basically means the footnote that we have to do it here is nothing but this one. Now, this is, I have taken the information from here, and this is a technical error here. It should be IBID. It should basically mean that the above source. So here I have taken the information from a very credible source. It's the Economic and Political Weekly. So I have taken it and I have cited it. So that's because I have taken this entire information from a particular source, and I have tried to write it in my own words. Then after that, this particular format, that's all available in the 19th style of citation. And then after that, here I have cited the one of the articles of the Constitution as it is. Now, when you cite something as it is, one important thing to note is you have to always put it in quotations and then cite it. because you're taking the exact wording from a different source. And when you write the thing, then you just cite it through the form of footnote number 7. I have done it here. It's through a journal article through one of the law institutes in India. So this is the way of formatting, and this citing, this is the, and this way of format, this is available online. Just write 19th style blue book citation. You will be able to find one PDF document in the first Google search, and that is the one that you can follow for all of your research articles. And then after that, these are, and you always have to cite, like even if you're using a statute, let's say I use this statute, you have to cite that as well, because you're taking some information from there as well. And then these are the case laws that I have mentioned. Case laws are very important in a research article to be able to prove your arguments. Now, one thing that we have to keep in mind is when you're analyzing, my entire paper is about analyzing certain part of the law. I have used case laws and statutes to be able to be analyzing the same alongside with few secondary sources like articles and books. So when you're using case laws, you have to explain them, what the case law said, and what is your relevance to the particular topic. And then after everything is done, you give conclusions and recommend and suggestions. So these are some, I have given suggestions in a very brief format, but you should always aim at giving it in a very detailed way as possible, because there's this thing called as framework. So to not be able to destabilize your framework, your recommending framework, always ensure it is as detailed as possible and there are no loopholes. Of course, loopholes will exist. Your aim as a researcher is to reduce the loopholes to the maximum extent possible.
Yes, and yeah, Pushpit, let's get to the other reports also. If you
Sure.
could just go on the screen share. So point is that it is not that every word you are writing yourself. Okay, so yes, you are taking it from case laws, but you are really, it's like compiling information which is authentic, which is relevant in a very nice fashion. And yes, you are making it your own. By at the end, the conclusion is yours. So typically in a, let's say, a 5-page report, at least I would say maybe 1 or 2 pages would be your own, and not everybody can write on their own, right? So, and it's not easy to write, but at least you should be smart enough to compile the relevant information, right? Okay, what we are going to do is we are just going to look at let's push with the other one. Can we start off with not this one, but can we look at the
Report number?
yeah, I think not this one, I think on the
So is it the arbitration one?
Yeah, the arbitration. We can quickly start with the arbitration one, and then we will go to the IPR one.
Yes.
Yeah. So this is okay. Now this particular report is corporate choices in international arbitration. Okay, this is made by PwC. Okay, one of the best and the biggest global firms in the world, PricewaterhouseCoopers. Okay, so if you look at the style, obviously these are, lot of time, money, and effort has gone into making these reports. We are not saying that you should become an expert in putting pictures and all, but yes, it does. Reports, when they are presented, yes, it looks good. People want to read it also. Yes, as students, you will probably, somebody else probably in the team is responsible for putting pictures and captions and layouts, but look at the content side of it, and that is what we need to focus on. And yes, whenever we are presenting a report, it needs to look attractive also, so that people are, you can highlight the important parts. They know what to focus on, not to focus on. So let's yeah, should we start off from? Yeah. So this is about choice of dispute resolution mechanisms, arbitration, the preferred choice of industries. Okay. Yeah, let's quickly run through this. And what we will also try to do is send to all of you. Pushpit, it's okay. We'll send your report also, which you have made, and we'll send all these 3-4 reports also to all of you. So at your own free time, you can study them. These are all from public information. So it's not that we have paid for these reports. These are available. If you will do a Google search, you will also find them. But we have made a lot of effort to find the right kind of reports which we feel can become benchmarks for all of you. That this is what an ultimate global research report looks like. Okay. Yeah, can we go through this quickly? Yeah, so the same information is also presented in a format like whether it is made by a consulting firm or a law firm will also make a difference. Consulting firms are essentially making the research reports for the industry, okay, and they are also presenting a lot of surveys which they may have conducted, but it is how you present that information. There could be pie charts. You could just say that 10% people are using this, 20% using this, but if you're presenting it properly, then a pie chart or a bar chart makes it easier for users to very quickly understand the reports. Like in a PPT also, we try to use, rather than just putting that information factually in words, we also try to make tables, make comparative analysis, so that it's just quicker and easier for people to understand and absorb that information. Okay, let's look at the other World Trade Organization report, Pushpit.
Yes. So the China one?
No, not the China one. Yeah, so this is again a report which is made by the World Intellectual Property Rights Development Policy, okay, Commission on Intellectual Property Rights. So obviously this is made by the global leaders in the field, okay. So yeah, we can quickly go over it. Yeah, okay. So here typically they will start off with the preface, but let's look at the content side, okay. And we are talking about a major research report, okay. Let's just focus on the contents to start with. So I think the most important part is when you are making a long research report is to focus on the, can you go over to the contents one, Pushpit? Yeah.
Yes, sir.
Yeah, so let's just focus on the contents of it. What all does it include? Yeah, even before that, I think the first, you have come to the 11th page. I think the first few ones will be the contents, right?
So the index?
Yeah, the index, sorry. Yeah. Yeah, you can call it index or you can call it contents. And, obviously we use slightly different words depending on our countries where we are based. And it doesn't really matter whether we put contents or index. But this is, I think, the starting point, whether you're writing a book or you're writing a large research report. I think start off from making the contents or the index, because this is what we would call the skeleton of the report, so that you do not miss out anything important even before you start. I think it's best to focus on the index or the contents of the research report. But like, these are the points which I want to focus on. So we could call them chapters. We have the headings, and then we have what we call the subheadings under each chapter. So for intellectual property and development, we have the introduction, and within introduction, we have the rationale for IP protection, introduction, patents, copyright, the history, evidence about IP, context, okay, and so on. Let's go to the chapter 3, 4. Yeah, okay. Let's look at any other agriculture and genetic resources. So again, we have the introduction within that chapter. And if it is an unrelated chapter, then yes, we starting from introduction and background, I think it is important. Only thing is that we should not spend too much time. I've seen too many reports where 80% of it is all about introduction and background. Okay, now it should not be more than 10 or 15% to give any reader, you could say, who has never heard of that topic also. Okay, so important to focus on introduction and background, but it should be limited to maybe 10-15% max of your report. Okay. And obviously the focus is on, and it is so important for you to choose your chapters or main points to start with. Because if you then, because it's like running in the wrong direction. Okay, you have to point from A to B, you have to go and you start putting in points C and D, which are not relevant. So important to get this thing right. Once you've got it right, then you start focusing on the, first you highlight the main chapters and then we focus on the sub points or the bullet points within that main section. And once you get that right, you start doing your research. Yeah, can we go into the after chapter? Yeah, and then obviously there is an overview. Now we are talking about, obviously teams of people have put in a lot of effort to make this kind of a report. We have about 4 or 5 sample reports which we can discuss, but a very large number of people. So we are not expecting you to make reports like this, but eventually you could become part of those teams which are making these kind of reports. And yes, there is usually an editor or somebody. It's like if you're making a movie, then you have a director who is saying, okay, who will be the star to do what role, and somebody has to put it all together, right? And it's usually a team effort, but deliberately for our internship, we have not put in teams because you need very good understanding and the level has to be the same. So when companies or law firms make reports, they know what is the capability of which individual, because you don't want different sections to completely, people think differently at times. So it has to have the same flow. So it's good because then when you make your reports, you have control over what you are doing. You may not have control over what the other people who are contributing to that report. You could be hardworking and sincere and trying to do a good job, but if the other people are not doing it correctly, the whole report will suffer. So they'll have great 5 chapters, but the 7th chapter will be bad because somebody didn't put in a lot of effort. So initially, it's best to make reports independently, and then once you are of a caliber which can be standardized, then teams can be put across to make reports, and then you get separate sections to work on those reports. Yeah, let's quickly go over this report, and anything important, Pushpit, you can focus on any page and highlight it as well.
I just want to highlight that, as you can see, there are different headings, subheadings, as I earlier mentioned. It's very important to be able to identify them because it gets very mundane for a reader to be able to read that, because it also gets difficult for them to understand what you're trying to say. So if you talk about growth and innovation, then they know that yes, you're talking about growth and innovation, but it's really difficult to understand that if there was, let's say there was this no heading here and you transitioned from this paragraph to this paragraph, it will be very difficult to understand. Then also they have given the references in the form of endnotes, that's at the very last. So that's different way of, again, citing, but they have cited it as well. So respecting other people's work and also putting your own work in are both go hand in hand and are complementary to each other. Right here.
Yeah, plus obviously reports using different colors, using sometimes different fonts, even pictures. Yes, you don't want to put the person who's reading it go to sleep, right? So you make it interesting by ensuring proper headings, focusing what is to look at. And usually reports also, people who are viewing it also are not going to spend too much time on it, so briefly people have to quickly go over it, give them, like typically somebody would take 15-20 minutes, half an hour max over a report. Okay, so yes, the report itself could be 200 pages long, but then people, once they find it interesting, you've captured their interest, then people will read each and every word of it. But if you haven't been able to demonstrate that yes, it is authentic, it is important, it is going to add, see, people are also, by reading it, they are devoting time. Okay, a good professional is devoting his time to read your reports, so it better be worth it, right? We don't want something which is already available, haphazard. Nobody has time to waste, right? So very, very critical to ensure that the reports that you are making are relevant, authentic, and in many ways to the point. So making long reports sometimes is very easy, but making it short, precise, and again, making those 2-page notes are much more difficult than making maybe a 200-page report, right? So focus on some of these points. And can we just quickly go over this and complete this and go right to the end? So this, and small things like page numbering, having a footer, having the heading, very important. And when we say 2-page report, then we are also kind of standardized it. We have given you the font size. So we've had reports where somebody puts the font size to, let's say, 18 and says, okay, so we need to standardize. Ideally, we are looking at number of words or number of push. Is that correct? We're looking at number of in a
So,
report. Yeah.
in a research report, it is between 6,000 words to 10,000 words, and in a research note, we have gone through page wise. That is between 3 pages and 5 pages.
Right. So that kind of standardizes it. Okay. And do we show one more report? Can we show? Yeah.
Sure.
And very soon after this, we will get on to some of the reports which all of you have made also. And yeah, this is again made by Maipo. This is intellectual property Q&A, and this report is made by China National Intellectual Property Administration, right? So it's about intellectual property rights in China. Okay. Now, even if we don't live in China, we are not students of law in China, but China is why we've selected is one of the biggest. If you look at it from a commercial point of view, China is one of the biggest markets in the world today, and they're also one of the biggest manufacturers. So anybody who's producing anything, you cannot ignore large countries. So important to get, if you want to get to know more about intellectual property rights in China, then this is the kind of reports which one will look at, and look at how detailed the report is. And I can assure you, if any of you, we don't have time right now, but we could have a 3 or a 5-hour session just on this particular report. And if you study this well, you will actually become an expert on Chinese IPR policies and rules and regulations, right? And how many English-speaking lawyers would be there? Very, very few in the world who would really, yes. So making the report, somebody has spent so much time in making those reports, but we as not just law students, but as lawyers need to, so the material is there. We need to understand, read it, and absorb the information. And again, it is not rocket science. If you will read it, it's like reading a book. So I would, yes, you're all studying in your colleges, you have your classrooms, and you have all these exams to pass, but this is the practical side. If you pick up this kind of information, something like this might not be in your course curriculum, but this is what will really help you in finding good jobs. And if you eventually will, if anybody wants to specialize in IPR, work with global organizations, consulting firms, law firms, large corporates. If you can demonstrate that you have this kind of information with you, definitely you will have a huge edge over any other student or candidate. Okay, even if it's clients, they will value somebody who has this kind of exposure. Okay, you may not have the experience, but you will have exposure to these kind of reports. And all this is publicly available. We have not paid money. You don't have to pay any money, subscribe to a lot of, you'll say, I can't afford this, or I don't have the budget. It's available for free, right? But you have to just find the right sources. We've spent a lot of time and energy, Pushpit and other members have spent a lot of time in finding these kind of reports. In fact, in our, some of you have already completed the professional courses or are still doing it, and even in master classes. So we are continuously getting the right reports and adding it. And anybody who's doing a course, it's a lifetime kind of a course you have. And we are constantly upgrading information on these courses. Okay, some are our own research and some which is already available. We are compiling it and putting it there. So it's like a resource center for you. And it's not just for students, actually, it's for lawyers from all across the world who, when they want to get updated information, they can go in, whether it is IPR, cyber law, international arbitration, M&A, you name it. And we are also introducing more information on uh, laws relating to, again, as I mentioned last time, the American legal system or the UK legal system, the Singapore legal system, because these are globally very, very important jurisdictions. We cannot ignore them. We could be living in any country. Yes, we have to master the legal systems on the country in which we live in, because that affects us. Maximum work will be done. But if we understand more, so it's going beyond what you normally are supposed to study. All of us, whether whichever country we live in, we understand the legal system, and that is what your colleges are supposed to teach you. Okay, but the practical side you need to pick up, and internationally what all we can do. And the moment we acquire more information, we are upgrading our level, and this is where we are able to differentiate from other students, other lawyers, in terms of whether it is a hiring process for internships or for jobs, or when clients are also shopping for lawyers or law firms. Large corporates also, they interview a few lawyers of different law firms, and they pick up the ones where they feel the individual lawyers have maximum exposure and experience. Experience will only come from practical side, but exposure to really what is happening is something which we can pick up. The information is available. We also are putting in and compiling more YouTube videos. There are so many conferences, the International Bar Association in UK or US, constantly in Singapore, we are constantly having so many conventions and debates and webinars. So we are also compiling good ones so that we can share with you, and you can again watch the YouTube videos, learn from the experts. Okay. Right. Okay. So should we just go on, Pushpit, now to quickly go over some of the reports which we have received, the research reports?
Yes.
Okay. So first of all, thanks to all those who have submitted your research reports and articles. Obviously, the deadline is 25th. After 25th, we will not accept any. But I had requested all of you to start submitting it in. And we have excellent topics. We've also identified, again, as I mentioned, there are 13 students we have identified from the ones we have received the reports. Pushpit, would you just quickly go over their names and their title?
Yes, sir. Just a second.
Just their name, student name, and the title which they have selected.
Yes, just a second.
First, the 13 names. So the first one is Tanishq Tharoor. The seat is an international commercial arbitration was the topic. Pushpit, have you got this now?
Yes.
Yeah, okay. You want to go over it quickly?
Sir, I don't have the report as of now, but
okay, no problem. We'll just go over the names of the students and the
sure.
time.
So the second one is Pavitra Rajesh. Her topic was blockchain and innovation and need for regulation. Then the third one is Varshan Bhan. Her topic was liberty and law. Fourth one is Yashika Jain. Her theme was maritime law. Then fifth one is Tejasvi Maripudi. Her topic was law on limitation period under banking law. Sixth person is Henal Shah. Her topic was impact of COVID-19 on labor laws and workforce. Seventh one was Tupakula Nikhil. The topic was the doctrine of election, perspectives of United Kingdom and India. Eighth is Avni Tiwari. Her topic was commercialization of intellectual property, licensing. Then the ninth person is Sai Teja Swaroop. The topic was need for sui generis legislation for the protection of indigenous IP and traditional knowledge of India. 10th person is Abhinav Shukla. Topic was cybercrimes in COVID-19. 11th is Shubhangi Agarwal. The topic is the bail buying case of India. 12th is Riya Shetty. The topic was Yatinoza contempt proceedings. And 13th person is Chakraborty Supratik. The topic was the legitimacy of children born out of live-in relationships.
Okay, these are just 13 names we have selected. All the other reports are also very, very good. But these, we just wanted to give a special mention because they, I think, have aced it completely. Yes, they can still improve it, but these are the names of 13 students where we feel that they have really done a great job. Maybe they have earlier experiences in writing research reports, but the others are also, so these are what we are saying A pluses, the other are all A's as well, and interesting topics. And we will try to share some of the good research reports written by students only with each other. So at the end of it, the idea is that we should be able to, and again, it is there as an author, they have made those reports. And some of the best ones, we will publish it on SFLRE, the Society for Legal Reforms and Education website also in the near future. But obviously we cannot put all the reports, and we may have to modify them to, if there's something lacking, then we will need to make sure that they are 100% to that standard where we can publish them ourselves. But yes, reports are really good. This is your content. You're also free to upload it and share it, the ones which you have written, to your friends, colleagues, and maybe it's your property really, to that extent, right? So, and the idea again is to improve. How do we, the citations, case laws, indexes, conclusions, and all the finer points, how do we kind of specify and make sure that we are improving them? And also the fact that these are what we have mentioned are basic broad guidelines. I'm getting a lot of queries where people are saying, but if I can't do this, then what happens? Absolutely, these are guidelines. Even the PwC report or the WIPO report, yes, this is what they used. And so there is a standard format which we are trying to suggest to you. Okay, nowhere is it written in stone that this is how it has to be. And if it's not like this, then it's not a good report. But in case you do not have a kind of a format or a template, then we follow this format. And then obviously everybody will find their own style and their own method to it, right? So that is the general idea behind this. Do we have some of these people also right now on Zoom? Can we quickly speak to them? And then we will also open up for any specific questions. But do we have Tanish, Tarur, and all the 13 names we mentioned? Are they on this Zoom session right now? And
good evening, sir. I am Avneet Tiwari, and my report was shortlisted commercialization of IP licensing agreements.
Excellent. So how much time did you take to complete your report?
Sir, it took me around 2 to 3 days.
Okay, that's fantastic. In 2 to 3 days, if you can make such a good report, imagine what you would do if you have a month to make a great report.
Thank you, sir, for reading it, and it is very motivating, sir, getting such feedbacks.
We will get good reports, and at the end of the session, with your permission, we will then share the reports with other students.
Sure.
Right? And the other students who get it don't have to cut and copy and paste it and make it your own, right? So as long as please understand that if you will ever read, quote anything, then you must quote Avneet Tiwari as the source of that original report. Okay, keep that in mind. Yes, do we have anybody else who's there right now? Thank you, Avneet.
Yes, hello. Good evening, sir. This is Tanish here. I wrote the report on seat in an international commercial arbitration.
Excellent, excellent. So tell us a little bit more about your report.
So basically, there's like a raging debate in international commercial arbitration between the seat and the venue. And so basically, there's diverging opinions within the court itself and the judges themselves. So in many cases, when the arbitration clause is not drafted with specific usage of words like seat or venue, there often arises a dispute regarding the same. And in some cases, the place itself has been taken to mean the seat, and in some cases it has not. And that the seat in itself affects also the law governing the arbitration agreement in itself. So that was a very interesting topic for me personally.
Right. So what you're saying is that the seat can be different from the venue.
Indeed, yes.
Right. And seat is more important than the venue. And obviously, because with hearings on the virtual platforms, okay, it could be anywhere, right? I know for sure the seat could be in UK or Singapore, and the hearing could actually happen in any other country.
Yes.
And to reduce cost, especially the London Arbitration Center, Singapore Arbitration Center, because the costs were so high for people to travel physically there, right? So what is happening, especially in international arbitration, it is important because, first of all, when two parties are fighting with each other, obviously it's a dispute. That's why they're not agreeing on anything. They don't want to adhere to either one country's jurisdiction in terms of laws. So let's say Kenya and let's say France, there are two parties, one in France, one in Kenya. Now there is a dispute with them, right? So the party in France wants it in French. The one in Kenya does not, so language itself is an issue. So probably they will choose Dubai, Singapore, or London as the place for international arbitration.
Yes.
So the rules of these countries, which they choose beforehand, and it will be part of that agreement, they will choose the seat because the laws of that particular arbitration center will be used.
Yes.
But the place where the hearing is happening could vary, and it could again now be on the virtual format itself. So,
exactly.
So this is the beauty of again the cost is such an important part of dispute resolution as well, because you cannot imagine some countries have visa issues in COVID time. Nobody will, so but before COVID also, these were the new developments which are happening in the arbitration center. So thank you so much, Tanish.
Thank you so much, sir, for this opportunity.
Yeah, and who else is there right now from this list?
Hello.
Yeah, just introduce yourself.
Good evening, sir. My name is Shubhangi. My topic was the bail buying case of India.
Congratulations, Shubhangi.
Thank you, sir. Really appreciate these meetings and these special mentions. It's really motivating.
No, it's good because you have, see, other reports are also good, but what this means is that you have given attention to detail. So quickly, what is the bail buying case? You want to just briefly introduce the topic?
Yes, sir. It's a Delhi High Court case actually. And what happened in this case that the petitioner is for anticipatory bail. And instead of giving that bail, the judge asks the petitioner to provide some basic maintenance to the wife. So this is a case between a couple. And the counsel for the petitioner states that this might amount to buying the bail because even before, this is not a bail application, this is an anticipatory bail application. And by asking the petitioner to pay a certain amount would almost be like giving a premature judgment of some sort. Sure. So this is where I wanted to ask you a question, sir. So in certain research articles, for example, this one, the research gap has come into action because of a court judgment. How do you write an article without criticizing a judgment like that?
That's the tricky part. Yes, okay, that is the tricky part because you cannot criticize the judgment per se. You cannot say, without even quoting this particular case, but you cannot say that that judgment is wrong. You may, have difference of like some points were not covered, and obviously that could also just a high court judgment. So it could go to the Supreme Court. Probably it will go also. And the higher courts in any country can overturn the judgment of any lower court, right? But so again, difficult to give a concrete answer to this question of yours. But yes, this is what it's an evolving process. Pushpit, you want to add something quickly to this?
Yes, sir. Just a small tip. We can't directly criticize the judge, obviously, but we can politely do it. We can tell that, but the alternative provisions exist, or this is the alternative way of going about it. Just put the alternative. That's a polite way of saying that the judgment has possible loopholes, rather than saying the judgment is directly wrong. Just say that the judgment can possibly have these loopholes that we need to also look at.
This is how it would in any case be going in when it is, it is being challenged, the judgment is being challenged in a higher court in any country. Okay. It is like some facts were either not presented or kind of overlooked, or new facts could have been coming in also, based on which it would be admitted in the higher courts for sure. Okay, thank you so much. Anyone else?
May I? Okay.
Yes, please.
Namaste, I am Tejas Swaroop. I'm from BMS Bangalore. And my
it's not very clear. I think. Can you just adjust your little bit?
Yes, just a minute. Just give me a minute. Hello.
Yes, please.
Am I clear now?
Yeah, a little bit. Or we'll come back to you. Just give us 2 minutes, and it's still not very clear. But well, Tejasvi, I think your topic was law on limited period under banking laws, right?
Swaroop, sir. Tejas Swaroop. The need for sui generis legislation for the protection of intellectual indigenous property and traditional knowledge in India.
Okay, great. Tejas Swaroop, thank you so much. But your voice, it's not very clear, so we'll probably take up a little bit later. But
yes,
thank you so much. You've done really well. Congratulations.
Oh, thank you.
Yeah. Okay. Anyone else?
I'll make sure to give that in the end, sir. I'll remind you if you forget. Yeah.
Yeah, but you'll have to fix your mic first.
Yes, I will.
Yeah. Okay. Yeah. Anyone else about the reports? Riya Shetty? Yeah, we can't hear you. Okay, you need to test your mics. Chakravarti?
Can you hear me, sir?
Yes, we can. Just introduce yourself and your report.
I am Supratik Chakravarti and I live in Kolkata, and I am a third year student at Amity University, Kolkata. And my topic was property rights of children born out of live-in relationship. So this was my topic. And
property rights of
the property rights of children born out of live-in
relationships. Interesting topic. It's really interesting topic. Excellent. You want to comment a little bit about your report in brief?
Actually, as you know, the concept of live-in relationship is very new in case of India, and I will like to talk about the landmark judgment, which was the name of the case is SPS Balasubramanian versus Surutian, in which the Supreme Court of India held that if a couple are living under the same roof for certain years, it is assumed that they are a couple. So the child born out of them are assumed to be legitimate. So this was
in terms of property rights for the child, right? Okay, great, excellent. Thank you. Thanks. Congratulations. Yeah. Anyone else? Okay, and from the group, anybody else wants to speak? Have any comments or questions right now? We are ready to take them as well. Just raise your hand.
There is a question in the chat box.
Yes.
It says that, sir, how many citations is like the ideal in a 10,000 word research?
You have the name of the person also?
Yes, it has been asked by Ashutosh Pandey.
Okay. Yeah, what is the question?
How many citations is like ideal in a 10,000 word research report?
Yeah.
So an ideal citation, it's a very difficult question because it honestly depends from topic to topic.
I know, that's why I wanted you to answer. There is no fixed standard that we will say you have 5 or 7 or 10, but I think reasonable is the word which is used in law a lot. Okay. Whatever you think is reasonable, right? You don't have to give 200 citations. You don't have to give just one. Be kind of, probably I would say 5, 7, 10.
So it honestly depends upon the topic. So if it's a topic like space law, then having 10 citations for that in itself is very great because it's a very niche topic. But if it's a constitutional law topic, then it's advisable to write more case laws, more alternative statutes is possible.
Right. Okay. Anybody else on the any questions or comments which anybody else has in the? You want to just raise your hand? Carolyn, are you getting this correctly? I think. Yeah. Hi.
Okay. Hi, everyone. First, congratulations to those students who had made relevant articles. I need to say that congratulations. As a lawyer, I'm very proud of you. So congratulations. I have a question about how it would be relevant to write about a comparative legislation about my country, for example, Brazil, related to India. Would it be interesting to write this comparative about the laws from both countries?
Absolutely. I think there'll be a great topic to write if you do a comparative analysis of the legal system, and it'll actually benefit everyone because we, not just in India or many parts of the world, see, the Brazil and India both are large economies. Okay, without making any political statement, these are large economies, right? Whether it's an American investor or an American company or somebody living in UK, everybody wants to do. If you look at any global company today, okay, if you look at the BRIC countries also, so yes, it is very important, and I will strongly suggest that you do this comparison. And if possible, you could include one or two more countries. You could do the comparative analysis of Brazil, India, you could include US, UK, if you so wish, or Commonwealth as well. And we are also trying to do these analysis because in the global environment, we have no idea how the other countries, jurisdictions, what are their legal systems. So since you are already a qualified lawyer in Brazil, excellent, you know about your legal system for sure. Okay. You will also gain so much knowledge if you write about the Indian legal system and if possible about one or two more jurisdictions. And
I have again a lot.
I would love to read your report to understand, and not just in India, but all over the world, what is the legal system in Brazil. I myself don't know. I'll be very frank about it. So it would increase my knowledge to learn more about the legal systems. And yes, write a report. And also I will suggest that you make a comparative chart. See, nothing like a chart where you write bullet points that what is your legal system, broadly speaking. Is it a jury system? Is it a judge system? What are the civil courts? Do we have a district court, sessions court, high court, Supreme Court? Probably it will be. So what are the similarities and what are the big differences? Right? So comparison is absolutely, and nobody's saying which is better. It is just a question of we want to understand what are the systems which are available. In fact, on the Chinese legal system, not much is available globally. So I'm sure in future somebody will pick up, and you don't have to be a Chinese national to do that. It's in English. Most of the laws are translated and available. So if you could, anybody wants to pick up, again, you don't have to pick up, but yes, your country's legal system, nobody knows it better than you. So great, Carolyn, go for it. And please submit the report so that we can share it with other members also very soon.
Okay, thank you so much.
Okay, thank you so much. Anybody else has any comments or questions?
So there's a question in the chat box.
Yes.
It's by Saptyani Prativi. She asks, I would like to ask a question, but due to my mic problem, I will just write it here. So regarding the legal articles, do you have any tips on how do we improve our structuralized analytical thinking skills?
Okay, first of all, everyone becomes better by practice. So keep writing, right? And don't bother about it, what others are saying. You will write your first one is the idea is to, the more you will write, the better you will automatically get. Share whatever you're writing with your friends, your teachers, your professors, send it across to us. There are so many other good organizations so that you can get feedback. Okay, and do not take any criticism in a negative fashion at all, ever. Okay, but I think analysis, all these things, you will just, the more you will do, the more you will practice, better you will become. Okay. So, but there is no fixed formula for how to pick up, the more you will write and the more you will read. So start reading also the good research articles, which we can also provide you, and they are available on the net. So the more you will read, more you will be able to write better as well, without copying from anywhere, right? So you don't have to read only the articles on your particular topic, read on other topics also, and you will automatically, we all need to keep improving, right? And we will automatically definitely improve as well, right?
Sir, can I add on to that?
Yeah, quickly.
Just a small thing, that question everything when you're reading it. Ask why it is there, what is it, and also ensure that it is multidisciplinary. As sir said, that don't restrict yourself to law. Also look at social sciences, look at science, and try to relate them as to how they're related. So that's pretty much about it.
Excellent. Anyone else? Any more question, comments quickly? I think we are already, will be closing soon. Raise your hand if anybody is on the Zoom. And Tejas Swaroop, you want to come in?
Am I clear now, sir?
Yes, you are.
Thank God, I've held my side of the bargain. Okay. So as I was saying, my research note was on the need for a sui generis legislation for the indigenous intellectual property and traditional knowledge of India. And funny enough,
I have a question before you start. So can you explain what sui generis is? I have no idea what it is.
Sui generis is one of a kind. It is something of a different kind. So when sui generis legislation is a law for its in a different kind.
My little
specifically for it.
Okay, great. So my little suggestion is,
yes, sir.
Great thing, but if you, instead of using sui generis where somebody has to Google what it means, if you would just simplify it for somebody, believe me, many people will not understand, but nobody will ask. And when they will not ask, they will not understand what it's about, and chances of the report being read, actually, you are diminishing your chances of somebody else reading the report, right? So let's use simpler terms if possible. Okay, and yes, now please go ahead, briefly explain. It's an important topic which you've got. So very briefly about your.
I mean, yeah. So the reason why I chose to write on this is because one thing that we know is that India has a very rich, it's a very diverse country. It's a very diverse country, meaning it also has, in terms of traditional knowledge, when we speak about connection of traditional people, when we talk about traditional people, this includes varieties of tribals that exist in India who have a very deep connection with the forests and the ecological systems, and they have their own. When we talk about science, every science develops within people in different ways in how they interact with nature. So traditional knowledge is something that is given a lot of importance when we talk about when we talk about medicine, which does not have side effects, to put it simply.
So are you talking about Ayurveda and herbal medication and not?
Sure, Ayurveda and herbal medication is one side of it. Because now, yes, sad. It is a sad story that even Ayurveda and such medical systems which belong to the majority of the country are not afforded enough protection. But keeping them aside, India also has a lot of tribal populations which by themselves have their own systems of traditional knowledge. And when put in application,
how do you connect it to intellectual property rights?
So the thing is, sir, that many of these knowledge systems in today's world are more preferred, because you go, let's say you have a headache, you go and you take a paracetamol. The next you do that 10 times, and the next thing you know, it's giving another disease. But the same problem when afforded by they use the word quirk to demean the idea or the system, but when used a more delicate or a more traditional system, the side effect part is cut off to a larger extent.
But I will still ask that question: where does intellectual property right come in?
Yes, I'm coming there. Yes. I'm coming there. I am really sorry.
I'm going to grill you on this.
You should excuse me because I have this habit of pulling things. But yes, so yeah. So the reason why I mentioned the word indigenous intellectual rights is firstly it's an established concept in international law. It is true that it is a concept which is dragging, but it is an established concept because cultural rights is something that the UN focuses a lot about. And there are many cases in the past where this property now this system has evolved through the brains of people who belong to these tribes. We might not be able to tag it to one person, but these are basically knowledge systems that belong to these tribes and can be misappropriated while they themselves don't get any benefit out of it. It is as good as saying I compose a tune, somebody picks it off, makes it, puts it into a different song system, and they publish it as their own.
Fantastic. I'm going to stop you a little bit because we can't go on too much on it. But just a quick, I'm going to add something which you're saying. But from a commercial point of view, whoever takes the patent first, it's their property, right? And I will give you a little example. Like acupuncture in China, very, very popular, globally accepted. I'm not sure what the current status is of patenting that system, but even things like yoga, which originally obviously started off from India, the postures, the poses which we have, everybody knows it started from the, and it's thousands of years old civilization. Yoga is practiced globally. It's just a good system to train yourself, body and mind. But you'll be surprised that majority of the postures of yoga are patented by American individuals and American companies. Okay, because they patented it first. So globally, and today, if yoga is taught in gyms like Fitness First and Anytime Fitness, which are global brands in 100 countries, they have gyms and all. Anybody who is using that system has to pay a franchise fee. Okay, so yes, I understand what you're saying, that indigenous, everything is fine, but if you do not go ahead and get these things,
I have to dissent with you over there, sir.
You can,
because because the same situation where neem extract. I put this case in my note also, where a company tried to patent it, and after 1 year, the Indian government got to know about it. We fought the case, and we made sure that the patent was cancelled.
Sure,
so
obviously.
While patenting is one thing, if we can prove that that is from our system, we did it first, we can get the patent cancelled, and that is something that we have to focus on.
Okay, so we understand that, but that is where it will go into either an international arbitration or into the courts to decide. But typically, whoever patents something first, it's like, so nobody should delay on patents, getting things done. Thank you so much. Appreciate your point. We don't have time to take it further.
Yes, and I appreciate the fact that you actually engaged in the debate, in the argument. Thank you, sir.
Debates are so important. And again, there is no right and wrong. What you're saying is right, absolutely. And you should never take anybody's word as final. Even if it's your senior, even if it's somebody who's got many years of experience, you can question. And that is what law is all about. We should ask those questions: why, what, how, where, and somebody has to prove it. And I think the idea is to force ourselves to think and say, okay, where is it written? If anybody's saying something, where is it documented? Where is it? And we always look at written documents and again, authentic sources. So whenever you read something, because there is so much on media, there is so much in news channels which one is reading, but again, coming back to it, finally, we need to again go to the right sources to verify everything. And as lawyers, I think that is what all our training should be about, that can we verify and check the authenticity of any information today. Okay. So thank you so much. Is there anyone else? Any other question, or we will... Pushpit, is there any other question, or anybody else wants to raise their hand?
So may I ask a question?
Yeah, short one, please. Yes.
Yes, I'll make sure. So we just discussed that case laws are a very good source of a primary source for research. However, in certain topics which I came across, I couldn't find many case laws, or it was scarce in nature. So should I take that as an opportunity to delve into that topic and research further, or should I steer clear of such a topic and go for topics which have more legal base?
No, no, absolutely. There are so many new areas in law where you may not have cases as such because the law itself might be relatively be new. Okay,
Yes.
that's fine, absolutely. And if you cannot find any case, then maybe not in the Supreme Courts or internationally. But if you can't, probably you will find something or the other, not directly connected, but remotely or distinctly connected also. So try to use.
Cases they have somewhat given some sources of knowledge, but there's no solid case that we
Yeah,
can.
yeah. That's fine if there isn't, because maybe the topic is new
Yes.
today. It's like drone law, let's say. Okay, the topic is so new that there might not be many disputes globally anywhere in the world right now.
Yes.
But drones are very popular, and their law is, every country now has very clear laws. Who can fly or make or fly a drone? Can it go into any area? Will it interfere with any aircraft taking place if you live near an airport? It could be used for spying. It could also be an encroachment on your privacy, because you could have a camera on the drone and it could be flying over a swimming pool or in a residential complex, right? So laws are there. Many countries might not even have made those laws, but existing laws, how can it be used to in relation to drones? So just an example, but yes, write all these articles. Interesting question. Thank you so much. Right. So we will soon be coming to an end. So idea is, again, and we're getting all the research reports, and really, believe me, such amazing topics all of you have chosen, and the reports which you can make out that you have spent a lot of time and effort in writing these. And idea is not to make a report in 2 hours or one day. Okay, so ideally spread it over 4-5 days time. Consistency is always important, right? And also a couple of points regarding the master classes and the professional courses. Okay, spend time. Don't be in a mad rush to just download a certificate. Okay, ideally the professional course should typically go on for a 2 months period. Okay, if not 2 months, at least a month. Okay, yes, for the sake of this internship we can try to finish it, and I'm deliberately trying to put more pressure on all of you, try to finish it in 5, 7, 10 days time. But there's no point in just downloading a certificate if you have not really gone through in detail. So there is a lot of information on them. Okay, only thing is, it is more to do with self-learning. Okay, we have a very simplistic MCQ. Everybody will pass it. It's designed that everybody will pass it, right? But idea is for you to really gather, watch the videos, go through all the research reports. There's so much additional information that somebody, and actually, if you want, we can tell you exactly which person has spent how many minutes or hours on each PDF file or on each video. Okay, so we don't want to embarrass anybody there by saying, okay, in 5 minutes time somebody went over a 200-page PDF. Okay, but if you do that, you are only cheating yourself. Okay, so don't cheat yourself. Be fair to yourself. Absorb the information, and it is not just that today you need to finish it. You need to, and nobody can focus more than 2 hours a day on any particular topic. Okay, so again, the idea is to, for this 1 month internship, also spend time on writing research reports, even spend time on reading research reports. Okay, and more information which you gather, again, from good law firms in your home countries and other countries' research reports also. And not just from law firms and lawyers, but also research reports from trade organizations, government bodies, consulting firms like McKinsey, PwC, EY, because they look at it more from a commercial point of view and not just a legal point of view. And to do well, I think you need to look at the business side of things also, and not always only think like a lawyer, because many times lawyers are not doing well because they do not look at holistic businesses. Okay, and they just say, I'm a lawyer, so I can only look at law side of it. You have to, if you talk to general counsels today of large companies, point is, or law firm, partners and senior people who are interacting directly with clients, you need to understand clients' businesses. What is it? What are the problems? What are the perceived problems they could have? And how can you help them grow their businesses? How can you help them cut their costs and grow businesses, compete in a very competitive environment? That is what a lawyer's role is today, and not just a traditional role of fighting a case or giving an opinion on any matter which is thrown at them. Okay, lawyers are now part of management team. So think on those lines. Think that you are working for a large company, and if you are the general counsel, what are the challenges which the managing director or CEO has, and put yourself in their shoes. So do look at understanding more about finance, about marketing, about HR, about corporate governance, company law, and the industry in which the company is in. Look at the industry, look at the competitors they have, look at the global competitors they have. Because today's day and age, because it is global, a company may be very happy in one domestic market, but very soon multinationals, larger multinationals will come and overnight take away all their customers and their businesses. So those are the risks. And this is what companies and management need to protect themselves. And that is what lawyers do, protect the companies, not just through the IPR, but also through the contracts. Okay, so think more in terms of that you are responsible for, put yourself in a CEO's position if you're advising a client. Look at a startup company, what are the challenges they have, and look at every function of business. Again, finance is a strong business function, operations, HR, IT, cyber law. All these you need to put yourself in, because this is what the CEO or the board of an organization, they have to juggle with. Anything which doesn't work well, then the company starts, the share prices start dropping. And most of these large companies are global companies operating in 100 countries, right from Brazil to China to Pakistan to Kathmandu to UK to every large organization today has a global presence or is wanting to have a global footprint. And they don't understand the laws in every country, and they cannot afford to have 100 lawyers for each country. So it is being centralized now. They will probably have one lawyer for Southeast Asia. I had a friend who was with PepsiCo, and he was head of their legal team for maybe 20 years. And he had an area of like 30 countries. And he just had law degree from Australia and India. But he was guiding PepsiCo for over 30 countries. So understanding that legal system, what Caroline had mentioned, that it is not just Brazil and India, but imagine if you are a general counsel of a large company and you have a region of 30, 40 countries, including European Union, including UK, including Africa. Africa itself, such a large country with so many countries, diverse legal system from Kenya to South Africa, Nairobi, Ethiopia, right? Egypt. So Middle East, there are so many different countries, Sharia law being applicable, not being applicable, how does it impact? And we are not just talking about corporate law, we're also looking at personal law. And these are because it is complex, that is why, as I keep mentioning, we as lawyers have jobs and we have opportunities. Okay, so with that, if there is any final question, we will then close for the day. Pushpit, is there any other question? Anybody else has any question? Final?
Hello, sir.
Yes, hello.
Hello. Can you hear me?
Can you just
Can you hear me?
identify yourself, please?
Okay, I'm Oken Sunday Chinwike, and I'm from Nigeria. third year law student of University of Ibadan.
Sure.
So I have a question. Actually, I submitted 2 of my reports 2 days ago, and somehow I omitted the cover page. I don't know if there is any way to correct that.
Yeah, okay, so more of a technical question, but yes, ideally what we want is, many of you have been sending reports by emails also, but really we are we just have 2-3 people working in our team, and so ideally we want everything to go on the Google Forms which we have. And Parth, you want to comment on this, how if somebody can, and please do not send in reports by email, they need to be uploaded on the Google Forms. Parth, you want to add something on this?
Yeah, so once he has uploaded his form for the particular research report, he can't upload that again. So if he wishes, he can send his updated report on the email, but ideally, like, everyone should upload on the Google form itself.
Okay, so on the system itself, it's difficult to modify a report. So
Yeah,
as a special case, send it by email, but otherwise, once you're uploading, be careful what you're uploading, and please send them fast to get more feedback. And we are not going to publicize who got what kind of a grade. So either it's an A+ or it's an A for everybody else. But yes, good reports we will share, and we will modify them also. So please start submitting, because if you don't submit and you keep trying to wait for a perfect report, the internship will be over. So don't wait till the 25th. In your mind, maximum 20th, you should have everything coming in. And please don't wait. It's already 19th. Next 1 or 2 days time, please submit whatever reports you have. Work on your master classes and your professional courses. And I know there are a lot of emails we have been receiving. My apologies for not able to answer to and reply to every individual. It's physically little difficult in our existing system, but we are trying our best. So my apologies for all that. And we will have one more last session of Zoom very soon, and we will let you know in advance where, and please, specifically, if you have any queries, then let us know. But what we will do is, probably by sometime by end of next week, we will have one last session for this internship. Hopefully by that time, you would have completed your masterclass and your professional course. Please give us feedback on the professional courses and masterclass also on the SFLRE portal, please. Because it's easier for us to monitor, get feedback, and whatever your feedback is, just put it there itself. It'll help you and it'll help us also to improve. We are also always trying to improve more content, what more is required, but your feedback is important to the society as well, the law society, and for us as well. Right. So with that, we will conclude today's session. So thank you so much for your time and patience. And if we have not been able to get back to you, then my apologies. We are trying our best. And we hope that even after this internship, all of you will stay connected and will learn from each other's reports and topics. And you're also making, professional connections for your future. So, from different countries, different parts of within different cities, systems are different, and that is what we are all trying to do. Also, as lawyers, also we are also constantly networking and connecting with professionals from all across the globe. The idea is that if somebody needs help on what is our area of expertise, we could add value, and we could take assistance from somebody where we do not have no one person knows it all for sure, right? But whom can you pick up the phone? Whom can you send an email to and expect a response? So finally, at the end of the day, it is all individuals there. It's not large companies. It's the individual which matters. So if you have, create and developing your professional network. Okay, it's not that what can I get from the other person, is you should ask yourself, what can I give to the other person first? And you will automatically start receiving. So with that note, thank you all of you for your time. And thank you so much, Pushpit, as well.
Thank you, sir. All the best.
Okay, thank you. Take care. Have a great